Where does the law come from? Does this question's answer seem hopelessly obvious to you? After all, law comes from legislatures and courts, and law is written in statute books and case opinions. That's an accurate answer, but it does not come anywhere near doing justice to the complexity of the law of wills and trusts. One complicating factor is the antiquity of law. Human beings probably have been concerned about the disposition of their property after death for as long as the concept of mine has been a part of human society. And that's a very long time. So for us, we turn to the Norman conquest of England in 1066, when the Duke of Normandy, William the Bastard, yes, he was a non-marital child, and yes, when you win, you get to write a story and call yourself the conqueror. He brought with him a new way to govern. This is called feudalism. Feudalism was founded on the idea that the king was the owner of all the land in the kingdom, which he parceled out to his major supporters, nobility, knights, vassals, just like it shows here. And in return for their promise, the major supporters would, theoretically give it all back to the king. So theoretically, the king controlled the disposition of the land on the death of its holder. However, eventually, land became heritable, so it was passing from the decedent to his eldest son. And it took a long time, but eventually statutes were passed allowing the making of wills of land. The story of personal property is somewhat different, but the important point is that the law of wills is statutory, and that today, in the United States, in theory at least, the legislatures of the various states, and I repeat, states, are in complete control of the passing of property at death. In addition, many of the antiquities of older statutes and decisional law created or were brought into modern law. Some of these antiquities are what one author notes is that they are the fossils. They're the fossil-like vocabulary that his name is William LaPiana. You'll see as you work through this course words like devise, devisee, bequest, legatee, testatrix, administratrix, and executrix. And as I pointed out, these are fossil-like vocabulary. On the other hand, as we're going to cover in this course, there's also the law of trusts. And the law of trusts was created by courts. And until the 20th century, in many states, the law of trust was barely represented in a statute, so they weren't published in books. Some states had very little trust law of any kind. Many courts found themselves relying on decisional law from other jurisdictions, including England. And, as pointed out with the fossil-like vocabulary, as with the law of wills, there are a lot of fossils embedded in the, modern structure of the law of trust. At the beginning of the 21st century, though, the law of trusts and wills entered a new era. The new era of laws and of wills and trusts included the promulgation of the Uniform Probate Code, also called the UPC. This happened in 1969. And If you've taken a contracts course, you have heard of the Uniform Commercial Code, which is the UCC. And the UCC and the UPC were both the work of the National Conference of Commissioners on Uniform State Laws. Now, that's a long name, so they shortened it finally to the Uniform Law Commission, or also known as ULC. And the Uniform Law Commission writes statutes that can be adopted in other states. It's not necessary that a state adopt the entire code that the Uniform Law Commission drafts, such as the UPC, but it is available for state legislatures to draw from. So a little more on that history. Although the UPC has not been anywhere near as widely adopted as the UCC, the Uniform Commercial Code, it's been extremely influential. And parts of the UPC are sometimes used in individual sections and sometimes larger portions. And in a minute, in one of the slides coming up, you're going to see how Florida has used the UPC in designing its current laws called the Probate Code. Now, recent history also includes the law of trusts, which has gone through a similar development as the law of wills. As you can see on this side of the slide, the Uniform Trust Code was promulgated in 2000 by the same group, the Uniform Law Commission, ULC. And this one has been more widely adopted in more states than the Uniform Probate Code has. All right, so let's bring that past and the present into perspective and look at Florida law, because in this class we're going to be dealing with estates and estate administration that deals with Florida law. That would obviously require we understand Florida law. In addition, there's tax law, which is federal law, and it's not being covered in this presentation. We'll probably cover that later on in this, well, we will be covering it later on in the semester. For now, we need to recognize that wills and trusts are both governed mostly, and there's a caveat you'll learn about later, wills through the Florida Probate Code and trusts through the Uniform Trust Code of the state of Florida. All right. So when we look at wills, the Florida Probate Code is based on the Uniform Probate Code. So Florida has adopted pieces and parts of the Uniform Probate Code and, you know, as you might say, made it their own, made it our own, just for the state of Florida by the legislature. There are different chapters of the Florida Probate Code. If you go to the Florida statutes, and I recommend you go to www.flsenate.gov, where you can find the link to laws, and under that link find statutes, and you will see that there are several titles, and within each title are several chapters. Chapter 731, you will see it says Probate Code and then General Provisions. Chapter 732 will say Probate Code, Intestate Succession and Wills. Chapter 733 will say Probate Code, Administration of Estates. And Chapter 734 will say Probate Code, Foreign Personal Representatives, Ancillary Administration. And finally, it will say Probate Code, Chapter 735, small estates. One thing important to you as a student researching the law is to recognize that just like the chapters of your textbook, the statutes are titled in such a way that you will understand what the context of the information in that chapter is about. So if I want just to know some general information or general laws about the probate code, I would look under Chapter 31 probably first and see what kinds of statutes are included in Chapter 31 that might help me. If I am needing to know about intestate estates, that's where a person dies without a will saying give this person that item and give this item to this person, whatever the case, and wills in general, I would go to Chapter 732 and look at the statutes there. When we get to administering a mock estate in this course, of course we're going to be working then more in Chapter 733, where you will be able to find statutes that govern administration of estates. We won't be dealing with foreign personal representatives or ancillary administration too much in this class, but if you need to in the work world, you know where to look. Chapter 734. And if you have a small estate, and that's defined by the statutes, what is the amount of property that defines an estate as a small one, I would find that answer right here in Chapter 735. So this is the Florida Probate Code in Florida. It's publicly available at the Florida Senate website, and you can look up these things, and you're going to be led to these as well in the course. Trusts, on the other hand, a quick little nugget of information that I found doing some research, is during the 2006 Florida legislative session, Chapter 736 was added to the Florida statutes. So it went from 735, and I believe there was a blank space in the statutes, and that's not uncommon. Intentionally, some chapters are just not there because it allows the statutes to be flexible and change later on. So what they did was they tried prior to 2006 to put the trust laws into statutory form. Remember earlier I discussed how a bunch of old laws were usually brought into trying to make statutes. And but anyway, as a result, they put that in statutory form. It was Chapter 737. All right, so here's the catch. In 2006, the legislature made a new chapter, and they called that chapter 736 right here. After 2007, January 1st of 2007, Chapter 37 was no longer, because it got supplanted by Chapter 36. I'm sorry, 736. So now today we would refer, if we're working with a trust and need to know what rules to follow, we would look to Chapter 736. And now, as I promised, there's always good little information here and there. I found an article, which is cited at the end of the document, that the new law in Chapter 736 is 40% of what was once in Chapter 737, right? The old law that they replaced in 2006, and it was 60% Uniform Trust Code. So that's an example. Florida is an example of how the uniform codes do not have to be adopted by the legislature in full, but that pieces and parts of it can be adopted, and they can still retain old laws and even change a little bit of the uniform laws that they adopt as needed to fit the law of the state. All right? Okay, so what's next? Let me see here. All right, so as I pointed out on one of the first slides, that both that the law comes from legislatures and it comes from courts. How does the court make law? Well, as pointed out earlier, state legislatures are in control of the laws that pass property at death. And cases, though, decided by appellate courts will also come into play in researching the law of wills and trusts. And we call these opinions. Now, an opinion, as you will learn in legal research and writing, if you haven't taken it already, is a published decision of an appellate case. It explains, it's the court's explanation of what happened in the appellate case. And an appeal is when someone is unhappy with a trial court's decision and they take it to the appeals court to see if the outcome can be different. Alright, so there are different types of opinions. So I'm right here in this second bullet. Some opinions interpret and apply enacted law. So the court is asked to interpret a statute or even interpret a rule of court, a court rule. In other words, someone didn't like the outcome in the trial court because they felt that the court applied or interpreted the rule of law incorrectly. And the appeals court will look at that decision of the trial court and decide if it should be upheld or not. There are also situations where the constitutionality of law comes into play, and the appeal is based on the constitutionality of a law of the state or the federal government. So published decisions might also be one that involves deciding the constitutionality of law. It's somewhat rare because mostly state legislatures are responsible for areas that pertain to property, which is the real foundational piece of wills, trusts, and estates. But I did find one example where two United States Supreme Court opinions invalidated federal statutes that were aimed at preventing the invalidation was aimed at preventing a fractionalized ownership interest in Native American lands. And so small interests, it was determined from this opinion, from these two opinions, that where someone has a Native American has a very small interest of land on a reservation, on protected lands, that the tribe in which the decedent was a member, rather than a law of intestacy or a will saying, please, this will go to my son or my daughter or my wife, would actually go to the tribe. And I didn't realize that until I came across this interesting article, or I should say a little blurb in a textbook. And that is interesting because we don't really see the United States government on a federal level getting much involved in this area of law except where taxation is concerned. But the Indian lands are different in terms of the laws that brought them into their protected status, and in some ways it might make sense that what happened there to keep that Indian land from being fractionalized, and a piece owned by so-and-so and another piece owned by so-and-so, until suddenly it's all gobbled up by independent people. But enough of that digression. We're talking about opinions, published decisions. In addition, common law principles might also be the subject of a decision where the court is applying established common law principles, meaning there's no rule, there isn't a statute, there isn't a rule, there isn't an administrative law. There is nothing governing this. The only thing that can govern this as being right or wrong is a common law principle. And or the court can create new common law principles. Common law is not something that's just relegated to ancient antiquity. All right? So that's how the court makes law. So we've discussed both the Florida law, and we've talked and how that's framed in state statutes of wills or trusts, and we also just now gave you an overview of both of how the court makes law, and how the court makes law can apply to both state and federal. All right. All right, so let's make sure we look also at substantive versus procedural law for this class. Substantive law is law that creates rights and duties. So the right to will property to another person upon my death it's a right. It's created by, it's a substantive law area. Wills, trusts, and estates. This class, PLA 2600, Wills, Trusts, and Estates, is saying, hey, this is substantive law of wills, trusts, and estates. So my right to will property to another person upon my death is a substantive area of law. My right to inherit property from someone is a substantive area of law. Right to make a trust. Duty, switching from rights to duties. Duty to pay taxes is a substantive area of law, and the duty to act as a fiduciary when administering an estate, if I were a personal representative, for example, would be a substantive area of law. Now, you'll notice I cited to our textbook in PLA 1003, and we also use that in Legal Research and Writing, PLA 1104, so that you know that everything that you're working with so far really does have a purpose. Next, procedural law. The difference, procedural law is defined as law that regulates how the legal system works. In other words, if I want to open an estate, I would turn to procedural law to find out how an estate is opened. If the attorney I work for asked me to prepare an inventory, I would turn to procedural law to find out how and when an inventory is required in an estate. If my lawyer that's supervising me asked me to send notice of a probate, I've got all the paperwork ready, a petition is all piled up here and all these little scraps of paper, and I'm supposed to, my lawyer says, send notice of that. Who do I send it to? And how do I send it? Do I have to mail it? Do I have to take it to these people and hand deliver it to them? Can I fax it? Can I email it? So what are the requirements of remember, this is how the system works. Or what are the contents and form of final accounting? Now I will warn you, and I think that's kind of coming up on the next slide, so I'll wait for the warning. And let me do that. Wait. So let's synthesize all these thoughts. We know where to find the law. We know the location of it, where it is, as in a statute or a rule or a case opinion. And so when a statute is directly applicable to the question that you need to answer for a client about their rights or duties, remember we're dealing with substantive law, the statute may also have been subject to many court decisions. So its meaning, its application under certain circumstances, etc., might explain more about what the statute, when the statute applies and what it all means. And another way of looking at this concept is that statutes aren't always clear. And you're going to experience sometimes a statute that just doesn't make sense to you in your schooling here. And so the courts know that sometimes statutes are written vaguely, and they also can apply to a lot of different situations. So the courts are in a position to interpret its meaning and interpret its application and when it applies and how it applies and under what circumstances. So the result is when you are seeking the answer to a question raised by a client's estate plan, or the client's desires in making an estate plan, remember that your research may include both statutes and cases. For your information, we will rely almost 100% on statutes. I can't think in this course, I can't think of any cases I give you because it's too important to really get to know these statutes. Now next, when you're faced with questions of law on how to navigate the legal system in administering an estate, you may turn mostly to the rules, remember, but statutes, you should look at statutes and rules whenever that's the case, because one may have more guidance than the other. And now, even when you're applying the rule to the legal system, you still may run into the situation where cases are necessary. All right? But for the purpose of this class, I want you to focus on statutes and rules. And when you are dealing with substantive law, the who can make a will, who will get a share of an estate if it's if one of the beneficiaries dies. How do I make a will? What do I have to sign it? And those sorts of substantive rights and duties, you're going to go to the statutes. And if you are looking into how to administer the estate, and we do that about halfway through the course, you're going to start with the rules, but please don't forget to look at the statutes also, because sometimes they also have some guidance. All right, so what else does it all mean? What does it all mean? When you're asked to complete an assignment, you will probably be led by me to a source of law. I usually give links on the internet to the source of law that you're going to apply in a given lesson. Use these links provided. Don't try to stray away, because I do set up these lessons so that they're very well planned out and very clean, as clean as they can get, so that you are going to the right place to get your rules of law. I recommend that you bookmark the 2 internet locations that I've given on this slide, the floridasenate.gov and the Florida Bar. The Florida Bar has the Florida probate rules. The statutes are on the floridasenate.gov. The key chapters of the statutes we're going to apply are chapters 731 through 736. The Florida probate rules as a whole, pieces and parts of it will be used for assignments. So it's very important that you understand that aspect of the lessons. Lastly, I have some references. As you know, if you've read the syllabus, you're required to use references. You're required, I should say, to provide me with the references that you use, and you can use it. And there's remember the ALWD format. It's called Allwood for short form. We call it Allwood. And there's more about this in the plagiarism and writing resources that I provide. And it's very important that you read those and understand, and also know that there's a reference sheet. I sometimes refer to that reference sheet as a citation cheat sheet. I've changed it to reference because it sounds better, like I'm not letting you cheat. But the point I'm making is that this last slide, I've given you the references to the materials that I used to tell you what I just told you. And so that's required, or in this class, or you get a 5% penalty on your assignment. And so cite your sources, include a reference list on the second page of it, and you will do just fine. In addition, use the reference sheet that I gave you, which is the cheat sheet that I also call it, because it tells you exactly how to cite to things, and you will have no problem passing that 5% of each assignment if you do that. All right? Very good then. That concludes this, and I hope you got a pretty good little understanding of where the law comes from, and how and what law is when we talk about the laws of wills and trusts. And fortunately, we're not dealing with feudalism or William the Bastard anymore. But we still run into this fossil-like vocabulary as we work through the textbook and other areas of the course. And use the statutes. Go to there first, in fact, and follow the rules that I provide. If I give you a link, use that link. Recognize the difference between substantive law and procedural law, as well as knowing that many times your research is going to involve more than one source of law, such as statutes and cases, or statutes, rules, and cases. All right? Thank you.